2300820M. This is Van Buren Township versus Lindsay Dineski.
Yes, ma'am, that's me.
On behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
I wouldn't say applying to a junior college is anything like going through the long and demanding journey of becoming a lawyer. In reality, she's the type of person who believes she understands a lot about constitutional topics and broader systems. She speaks with confidence and often feels very certain about her opinions. She also seems eager to suggest big changes, feeling ready to improve the whole system based on her own strong ideas and personal perspective.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution of both.
I thought you mentioned that you were studying to become a lawyer, so I was a little surprised by this. One of the first things taught in law school is the clear difference between an arraignment and a trial. These are two very different court steps, and each one serves a specific purpose. In one stage, a person enters a plea, and in another stage, evidence is presented. It might be helpful to take another look at how those two moments work within the legal process.
Plea not guilty.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In an interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well.
I'm sure this isn't the first time a court or its staff have been told they would be sued by someone who was simply very frustrated. Situations like that probably happen more often than people realize. It's not surprising that people sometimes react emotionally when they feel misunderstood or upset. At the end of the day, these moments usually reflect stress and confusion more than anything else, and they tend to get resolved with clear communication and calmer conversations.
Because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court's time.
It really feels like a poor use of the court's time, especially when the concern comes from someone who has filed several complaints or legal actions in the past. When people repeatedly challenge law enforcement or legal institutions because they don't agree with how things were handled, it can raise questions about how serious the claims are. In one example, a rejected lawsuit described an incident where the person accused county officers of unsafe driving and claimed that their behavior suddenly changed once a camera was turned on. The complaint also included common legal arguments about civil rights violations and objections to certain legal procedures, which courts often evaluate very carefully before moving forward.
The one who broke the
Miss-
law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the
Yes,
first
but
appearance where
I
you
could ask for it
respond.
to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
I honestly didn't think she would stop talking, and no offense is meant, but I'm having a hard time believing the story as it was told. It seems unlikely that the police would make an arrest for such a simple reason, without more details. There's usually more than one side to a situation like that, and the full context really matters. It's reasonable to question the story and want a clearer explanation before coming to any conclusions.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
That situation is actually handled through a completely separate legal process. You don't automatically have legal rights to a biological child who isn't yours. In some cases, a court can allow visitation, but only when the judge believes it's truly in the child's best interest. The court carefully looks at stability, behavior, and the overall situation before making any decisions. From the outside, it can sometimes seem like emotions and stress are driving reactions more than facts, which is why the court's role is to stay fair, thoughtful, and focused only on what's best for the child.
The court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her. And I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and neglect from Charles and the bio mother.
I'm starting to see a pattern where responsibility for the situation seems to be placed on everyone else rather than looking at personal choices or actions. There's a repeated belief that the biological parents caused the problems, while she views herself as the one who stepped in to make things better. At the same time, there are serious accusations made about the child's father, yet major life decisions were still made in that situation. Another claim being made is that the child's emotional state has changed simply because she hasn't had contact for a while. These kinds of situations are usually very complex, and it's difficult to reduce them to one simple cause without a clearer, more balanced view of the facts. Ramzan, even so, court orders aren't optional and must be followed. If someone ignores a judge's instructions, there can be serious legal consequences. A bond can be taken away, and the person may have to continue everything from inside a correctional facility rather than in their normal daily life. The system is designed to make sure people take legal rules seriously and understand that court decisions carry real weight.
And now he tried to kill me. He said he was suicidal and then kidnapped our child. And then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So
that's what I'm asking for the agreement, due to the fact I was not given any evidence.
I don't think the court places as much importance on personal expectations as some people might believe. At the end of the day, judges focus on rules, facts, and what the law actually requires. All right, everyone, that's where we'll wrap up today's video. There's another hearing coming up in a few days, and I'll be sure to share what happens next. A big thank you to Factor for sponsoring this video. And make sure to check the link in the description if you want to try their service. If you enjoyed the video, feel free to like it. And if not, you can dislike it. Don't forget to leave a comment below and subscribe with notifications turned on so you won't miss any future content.
Like, I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they used to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
and I would like to know why I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal.
April 20th with Judge Green, ma'am. The court will mail notice to the address that we have on file in this matter. Anything else, Ms. Manarino?
No, Your Honor. Thank you.
I do not consent to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is erroneous, and I will be taking legal action against this court for not dropping this today.